I never thought installing solar panels would turn into a legal nightmare that would cost me months of stress, thousands of dollars, and nearly my entire sanity. But when you live under the iron fist of a vindictive HOA president, anything is possible. My name is Brandon Nelson, and I purchased my home in the Sunridge Meadows subdivision in Phoenix, Arizona, back in 2019. It was a modest 3-bedroom ranch-style house with a decent backyard and a 2-car garage. The neighborhood was quiet, the streets were clean, and the HOA seemed reasonable enough during my initial research. I read through the covenants, conditions, and restrictions document before closing, and while it was extensive, nothing jumped out as particularly problematic. I figured as long as I kept my lawn maintained and my house painted in approved colors, I would be fine. For the first few years, that assumption held true. I paid my quarterly HOA fees of $200 without complaint. I attended exactly one homeowners meeting in 2020, realized it was mostly people arguing about trivial matters like mailbox styles and holiday decorations, and never went back. The HOA sent occasional notices about community events or reminders about trash pickup schedules, but otherwise left me alone. Life was peaceful. Everything changed in early 2024 when electricity prices in Arizona skyrocketed. My monthly bill went from a manageable $150 to over $300 during the summer months, when I needed air conditioning running constantly. Phoenix summers are brutal, with temperatures regularly exceeding 110 degrees, and running the AC is not optional unless you want to bake in your own home. I started researching ways to reduce my energy costs and quickly became interested in solar panels. Arizona gets more than 300 days of sunshine per year, making it one of the best states in the country for solar energy. The federal government was still offering tax credits for residential solar installations, and Arizona had additional state incentives. After getting quotes from several companies, I found a reputable installer called Desert Solar Solutions that offered a complete rooftop system for $28,000. With the federal tax credit and state rebates, my actual out-of-pocket cost would be closer to $18,000. The system would generate enough electricity to cover nearly all my usage, and the installer estimated I would break even on my investment in about 7 years. After that, I would essentially have free electricity for decades. I decided to move forward with the installation in March 2024. Before signing the contract, I did my due diligence and reviewed the HOA documents again, specifically looking for any restrictions on solar panels. The CCRs had been written in 2004, long before solar panels became commonplace, and they made no specific mention of them. There was a general clause about exterior modifications requiring architectural approval. But I had seen several homes in the neighborhood with satellite dishes and external AC units that clearly had not gone through any approval process. I assumed solar panels would fall into a similar category of acceptable home improvements. The installation took 3 days. The crew from Desert Solar Solutions was professional and efficient. They mounted 32 panels on my south-facing roof, using a racking system that did not penetrate the roof membrane, installed an inverter in my garage, and connected everything to the electrical panel. They coordinated with the local utility company to install a bidirectional meter that would track both the electricity I drew from the grid and the excess power my system fed back into it. By the end of the 3rd day, my home was generating clean solar energy, and I could watch in real time on my phone app as my electric meter ran backward during peak sunlight hours. I was thrilled. My first full month with the solar panels, My electric bill dropped to $43, which was just the basic connection fee. I had gone from paying over $300 to essentially nothing. The system was working even better than projected, and I calculated I might break even in 6 years instead of 7. I told my neighbors about my experience, and several of them expressed interest in getting solar panels themselves. That was when Patricia Donnelly entered my life like a tornado made of passive aggression and outdated fashion sense. Patricia was the HOA president, a position she had held for 6 consecutive years through what I can only assume was a combination of being the only person willing to do the job and intimidating anyone who dared run against her. She was in her mid-50s, with aggressively highlighted blonde hair that she wore in a style that had been popular sometime around 2003. She drove a white Lexus SUV with a bumper sticker that said "Proud HOA President" and personalized license plates that read, "HOA Boss." I had seen her around the neighborhood before, usually standing in her driveway with her arms crossed, surveying the street like a general inspecting troops. On April 18, 2024, I came home from work to find a certified letter taped to my front door. The return address was from the Sunridge Meadows Homeowners Association. I took it inside and opened it with growing unease. The letter was printed on official HOA letterhead and was signed by Patricia Donnelly in aggressive blue ink. It stated that my solar panel installation was in direct violation of Section 7.4 of the CCRs, which required all exterior modifications to receive written approval from the Architectural Review Committee before installation. The letter demanded that I immediately cease using the solar panels and submit a formal application for approval within 7 business days, or face penalties, including daily fines of $100. I read the letter 3 times, feeling my blood pressure rise with each reading. Section 7.4 did require architectural approval, but it was vague about what constituted a modification requiring approval. More importantly, the letter made no mention of whether my application would actually be approved. It simply demanded I go through the process retroactively, which seemed absurd given that the panels were already installed and functioning. I decided to be proactive and called Patricia directly. Her number was listed on the HOA website as the primary contact for all community matters. She answered on the second ring. Patricia Donnelly speaking. "Hi Patricia, this is Brandon Nelson from 4782 Saguaro Drive. I just received your letter about my solar panels." "Yes, Mr. Nelson. I trust you understand the seriousness of the violation." Her voice was clipped and formal, like she was reading from a script. "Well, that's actually why I'm calling. I reviewed the CCRs before installation and did not see any specific prohibition on solar panels. I understand the architectural approval requirement, but I was hoping we could resolve this without me having to remove anything. The panels are already installed and working. The CCRs are quite clear, Mr. Nelson. All exterior modifications require approval. No exceptions. You should have submitted an application before installation. I understand that now, but can I submit an application retroactively and get approval? The panels are professionally installed, they look clean and modern, and several neighbors have told me they look nice." There was a long pause. "Mr. Nelson, I will be frank with you. Solar panels are unsightly and damage property values. They make homes look industrial and cheap. Several residents have already complained to me about the appearance of your roof." "Several residents? Who complained?" "That information is confidential. The point is that your modification has generated complaints, and the board takes community aesthetics very seriously." I felt my jaw tighten. Patricia, Arizona law actually encourages solar energy. There are tax incentives specifically because the state wants more people to adopt renewable energy. And solar panels are extremely common in Phoenix. Half the homes in newer subdivisions have them. That may be true in newer developments with different CCRs, but Sunridge Meadows has standards. We pride ourselves on maintaining a consistent, attractive appearance throughout the community. Solar panels disrupt that consistency. So you're saying even if I submit an application, it will be denied? I'm saying the Architectural Review Committee will evaluate your application according to our established guidelines, which prioritize aesthetic harmony and property values. Now, you have 7 business days to submit your application. If you fail to do so, or if your application is denied and you do not remove the panels within the specified time frame, you will be subject to daily fines. Good day, Mr. Nelson. She hung up before I could respond. I sat on my couch, staring at the letter and feeling a mixture of anger and disbelief. I had spent $18,000 on a home improvement that was both legal and environmentally beneficial, and now some power-hungry HOA president was threatening to fine me unless I removed it. The whole situation felt absurd. I spent the next hour researching Arizona solar access laws. What I found gave me hope. Arizona Revised Statute Section 3318-16 specifically addressed solar energy devices in planned communities. The law stated that HOAs could not prohibit the installation of solar panels, though they could impose reasonable restrictions on placement to minimize visual impact. The law had been strengthened in 2022, with additional language that prevented HOAs from requiring removal of properly installed solar energy devices. Armed with this information, I drafted a response to Patricia's letter. I acknowledged that I should have submitted an architectural approval application before installation, apologized for the oversight, and submitted a formal application along with photographs of the installation, specifications of the equipment, and a copy of the state law regarding solar access rights. I emphasized that the panels were on the rear-facing slope of my roof, barely visible from the street, and professionally installed by a licensed contractor. I sent the application via certified mail to ensure Patricia could not claim she never received it. 2 weeks passed without a response. I checked my mail daily, expecting either approval or at least acknowledgement of my application. Nothing came. On May 3rd, exactly 14 days after I mailed my application, I received another certified letter from the HOA. This letter was even more aggressive than the first. It stated that my application had been reviewed by the Architectural Review Committee and was unanimously denied based on concerns about aesthetic impact and potential damage to property values. The letter further stated that I had 30 days to completely remove the solar panel system and restore my roof to its original condition. Failure to comply would result in daily fines of $100, and the HOA reserved the right to place a lien on my property to collect unpaid fines. I could not believe what I was reading. They were not just denying my application. They were ordering me to rip out an $18,000 system that was functioning perfectly and providing me enormous financial benefits. The letter made no mention of the state law I had cited, nor did it provide any real justification for the denial beyond vague concerns about aesthetics. I immediately called Patricia again. This time she did not answer. I left a voicemail asking her to call me back to discuss the denial. She never returned my call. Over the next week, I tried multiple times to reach Patricia or any other member of the HOA board. I called, I emailed, I even showed up at the HOA office during posted hours only to find it locked with no one inside. It became clear that they were stonewalling me, refusing to engage in any meaningful dialogue about the situation. On May 10th, I decided to consult with an attorney. I found a lawyer named Robert Mendez who specialized in HOA disputes and solar access rights. His office was in downtown Phoenix, in a modern glass building with a view of the mountains. Robert was in his early 40s, with dark hair going gray at the temples, and the calm, measured demeanor of someone who had seen every variety of HOA crazy. I laid out my entire situation for him, showing him the letters from Patricia, my application with supporting documents and the relevant Arizona statutes. He listened carefully, occasionally making notes on a legal pad. When I finished, he leaned back in his chair and sighed. "Mr. Nelson, I handle about a dozen cases like this every year, and they are all frustratingly similar. HOAs in Arizona often try to prohibit or force removal of solar panels, despite state law clearly protecting homeowners' rights to install them. The problem is that many HOA board members either do not know the law or think they can ignore it. So I'm protected by state law. They cannot force me to remove the panels, correct? Arizona Revised Statute 33-18-16 is very clear. An HOA cannot prohibit solar energy devices, and any provision in CCRs that does prohibit them is void and unenforceable. They can impose reasonable restrictions on placement, but those restrictions cannot significantly increase the cost or decrease the efficiency of the system. Based on what you have told me, your panels are on the south-facing slope of your roof, which is the optimal placement for energy generation. Any requirement to place them elsewhere would decrease efficiency, which means they cannot enforce such a requirement. What about their demand that I remove the system entirely, completely unenforceable? You have every right to keep your solar panels. However, here is where things get tricky. HOAs like yours often do not back down easily, even when they are clearly in the wrong. They will threaten fines, they will threaten liens, and they will make your life miserable hoping you will give up and comply. Most homeowners cannot afford to fight a lengthy legal battle, so they reluctantly remove their solar panels rather than deal with the stress and potential financial penalties. But the penalties are not legal, right? They cannot actually fine me for keeping solar panels that state law says I'm allowed to have. They cannot legally fine you, no, but they will try. And if you do not pay the fines, they will place a lien on your property. You would then have to go to court to have the lien removed and the fines invalidated. It is a war of attrition, and unfortunately, many HOAs have deeper pockets than individual homeowners. I felt my stomach sink. So what are my options? You have several paths forward. First, you can send a formal demand letter citing the state law and informing the HOA that their denial is invalid, and any fines they attempt to impose will be challenged in court. Sometimes that is enough to make them back down, especially if their attorney reviews the situation and tells them they will lose. Second, if they proceed with fines anyway, you can file a lawsuit seeking a declaratory judgment that your solar panels are protected by state law, and an injunction preventing the HOA from assessing fines or placing liens. Third, if the case goes to court and you prevail, Arizona law allows you to recover attorney fees from the HOA, which means they would have to pay for their mistake. How much would it cost to fight this in court? If it goes all the way to trial, probably $20,000 to $30,000 in legal fees. However, most cases settle once the HOA realizes they cannot win. My retainer is $5,000, which would cover initial correspondence and negotiations. If they do not back down and we have to file suit, we can discuss additional costs at that point. I did some quick mental math. I had spent $18,000 on the solar panels. Now I was looking at potentially another $5,000 or more in legal fees just to defend my right to keep them. The whole situation was infuriating, but I could not stomach the idea of caving to Patricia's unreasonable demands. "Let's send the demand letter," I said. "I want to give them one clear chance to back down before this escalates further." Robert drafted a detailed 5-page letter citing Arizona Revised Statute 33-1816, relevant case law, and the specific provisions that made the HOA's denial invalid. The letter demanded that the HOA withdraw its denial, approve my solar panel installation, and cease any threats of fines or liens. It concluded by noting that if the HOA did not comply within 14 days, I would file suit seeking declaratory relief, injunctive relief, and attorney fees. We sent the letter via certified mail to both Patricia Donnelly personally and the HOA's registered agent. I felt a small surge of satisfaction knowing that Patricia would have to sign for it and could not pretend she never received it. The 14 days passed with no response. On June 1, 2024, I received yet another certified letter from the HOA. This one was short and brutal. It stated that as of June 3rd, I would be assessed daily fines of $100 for each day the solar panels remained on my roof. The fines would continue until the panels were completely removed and the roof restored to its original condition. The letter was signed by Patricia and included a photocopy of the relevant CCR section, as if I had not already read it a dozen times. I forwarded the letter to Robert immediately. He called me within an hour. "They are not backing down," he said. "I recommend we file suit this week. The longer we wait, the more aggressive they will become." "Do it," I said. "I am not removing those panels." Robert filed a complaint in Maricopa County Superior Court on June 7, 2024. The lawsuit named the Sunridge Meadows Homeowners Association as the defendant and sought a declaratory judgment that my solar panels were protected by Arizona law, an injunction preventing the HOA from assessing fines or placing liens, and recovery of all attorney fees and costs. The complaint laid out the entire timeline of events, attached copies of all correspondence, and cited the relevant statutes and case law. We served the HOA with the complaint on June 10th. Under Arizona court rules, they had 20 days to file a response. In the meantime, the daily fines continued to accumulate. The HOA sent me monthly statements showing the growing balance. By the end of June, they claimed I owed them $2,800 in fines. I did not pay a cent, but seeing the numbers grow was stressful. I knew the fines were invalid, but the HOA was clearly preparing to place a lien on my property if I did not pay. On June 28th, the HOA filed its answer to my complaint. Their attorney was a lawyer named Gregory Walsh from a firm that specialized in representing homeowners associations. The answer denied nearly every allegation in my complaint and asserted that the HOA had every right to regulate the aesthetic appearance of homes in the community. The answer made only passing reference to the Arizona Solar Access Statute, claiming that the law allowed reasonable restrictions and that their denial was reasonable based on community standards. Robert read the answer and shook his head. "They are going to lose, but they are doubling down anyway." This happens more often than you would think. Some HOA boards are so convinced of their own authority that they refuse to admit when they are wrong. "Is there any chance they are actually right about this being a reasonable restriction?" I asked. "Zero chance." Arizona courts have consistently held that HOAs cannot prohibit solar panels or require their removal. The case law is clear. They might be able to require that panels be placed on less visible portions of the roof, but your panels are already on the rear slope, so even that argument does not apply. They are going to lose this case, and when they do, they are going to pay your attorney fees. The case moved slowly through the court system over the summer. We exchanged discovery requests, took depositions, and filed various motions. Throughout this process, Patricia Donnelly proved to be a difficult and hostile witness. During her deposition in August, she insisted that solar panels were ugly, that they ruined the neighborhood aesthetic, and that she had received numerous complaints from residents. When Robert asked her to provide documentation of these complaints, she could not produce a single written complaint, email, or letter. She claimed the complaints had been verbal, made during casual conversations around the neighborhood. Robert pressed her on the Arizona Solar Access Statute. Mrs. Donnelly, are you aware of Arizona Revised Statute 33-18-16? I am aware that there are various state laws, yes. Are you specifically aware that Arizona law prohibits HOAs from preventing the installation of solar energy devices? I am aware that HOAs have the authority to regulate the appearance of homes in their communities. That was not my question. Are you aware that Arizona law specifically protects homeowners' rights to install solar panels? Patricia shifted in her seat. I have been told that such a law exists, but our attorney advised us that we have the right to enforce our CCRs. Did your attorney specifically tell you that you could force Mr. Nelson to remove his solar panels? Our attorney advised us that we have broad authority to regulate exterior modifications. Robert leaned forward. Mrs. Donnelly, I am asking you a direct question. Did your attorney tell you that you could legally force Mr. Nelson to remove solar panels that are protected by state law? Patricia's face flushed. Our attorney told us to enforce our CCRs. The deposition continued in this vein for 2 hours. Patricia was evasive, hostile, and clearly convinced that she was right despite all evidence to the contrary. At one point, she actually said that state law should not override HOA rules because HOAs know what is best for their communities. Robert let that statement hang in the air for a moment before moving on. In September, Robert filed a motion for summary judgment, arguing that there were no disputed issues of material fact and that I was entitled to judgment as a matter of law. The motion included extensive briefing on the Arizona Solar Access Statute, case law from similar disputes, and evidence that my solar panels met all legal requirements. The HOA filed a response opposing the motion, but their arguments were thin and mostly consisted of repeating their claim that they had authority to regulate aesthetics. The hearing on the motion was scheduled for October 15, 2024. I took the day off work to attend. The courthouse was downtown, a large modern building with security checkpoints and marble floors. Robert and I met outside the courtroom 30 minutes before the hearing. How confident are you? I asked. Very confident, Robert said. The law is clearly on our side, and the HOA has not presented any valid legal argument for why they should be allowed to override state law. The only question is whether the judge will rule from the bench today or take the matter under advisement. The hearing was held in a small courtroom on the 4th floor. Judge Margaret Reyes presided. She was in her 50s, with dark hair pulled back in a bun and sharp, intelligent eyes. The HOA's attorney, Gregory Walsh, was already seated at the defense table when we entered. Judge Reyes called the hearing to order and asked Robert to present his arguments. Robert stood and delivered a clear, concise summary of the case. He explained that I had installed solar panels on my home, that the HOA had denied my architectural application and demanded removal, and that Arizona law specifically protected my right to have solar panels. He cited the statute, the relevant case law, and the evidence that my installation was professionally done and optimally placed. When Robert finished, Judge Reyes turned to Gregory Walsh. "Counsel, what is your response?" Walsh stood and launched into a lengthy argument about HOA authority and the importance of maintaining community standards. He claimed that the CCRs gave the HOA broad discretion to regulate exterior modifications, and that solar panels were a significant aesthetic change that justified denial. Judge Reyes interrupted him. "Counsel, I have read the briefing. I am familiar with Arizona Revised Statute 33-1816. How do you square your argument with the plain language of the statute, which says that HOAs cannot prohibit solar energy devices?" Walsh hesitated. "Your Honor, the statute allows for reasonable restrictions. Our position is that requiring panels to be placed in less visible locations, or prohibiting them entirely when they are visible from the street, constitutes a reasonable restriction. But Mr. Nelson's panels are on the rear slope of his roof, correct? They are barely visible from the street. They are visible from certain angles, Your Honor. And you are asking him to remove them entirely, not just relocate them." The Architectural Review Committee determined that there was no acceptable placement for solar panels on this particular property that would meet community aesthetic standards. Judge Reyes looked skeptical. "So your position is that the HOA can effectively prohibit solar panels by claiming that no placement is aesthetically acceptable?" "Our position is that the HOA has discretion to make that determination, Your Honor." Judge Reyes shook her head slightly. "Counsel, that interpretation would make the statute meaningless. If an HOA can simply declare that no placement is acceptable, then they are prohibiting solar panels, which is exactly what the statute forbids. I am not persuaded by your argument." My heart leaped. Judge Reyes was clearly on our side. The judge continued, "I am going to grant the plaintiff's motion for summary judgment. Mr. Nelson has the right under Arizona law to maintain his solar panels. The HOA's denial of his architectural application is invalid, and the HOA is enjoined from assessing any fines or placing any liens related to the solar panels. Furthermore, I am awarding attorney fees to the plaintiff, as provided under Arizona Revised Statute 33-1816. Counsel for the plaintiff should submit a detailed fee statement within 14 days. I wanted to jump up and cheer, but I managed to contain myself. Robert smiled and nodded at the judge. Walsh looked like he had swallowed something bitter. Judge Reyes signed the order on the spot, and the hearing was adjourned. Robert and I walked out of the courtroom together. "We won," I said, finally allowing myself to grin. "We absolutely won," Robert agreed, "and they are going to pay for it. Submit your fee statement and do not hold back. Include every hour I worked, every filing fee, every cost. They earned this." Over the next 2 weeks, Robert compiled a comprehensive fee statement detailing every hour he had worked on my case, from the initial consultation through the summary judgment hearing. The total came to $18,500. I signed off on it, and Robert filed it with the court. The HOA objected, claiming the fees were excessive. Judge Reyes held a brief hearing on the fee request and awarded the full amount. She noted in her order that the HOA had pursued a legally baseless position, despite clear statutory authority to the contrary, and that I was entitled to full compensation for the legal fees required to defend my rights. The judgment was entered on November 1st, 2024. The HOA had 30 days to pay the attorney fees and remove all fines from my account. They paid on November 29th, one day before the deadline. I imagine Patricia had to present the bill to the other board members and explain how her crusade against my solar panels had cost the association $18,500. But that was not the end of the story. In early December, I received a call from a woman named Diana Ramirez who lived 3 streets over from me. She had heard about my court victory through neighborhood gossip and wanted to tell me something. "Brandon, I have to tell you why Patricia really went after your solar panels," Diana said. Her husband owns a roofing company, and he is on the board of a trade group that represents traditional roofing contractors. They see solar installers as competition because solar companies often offer roofing repairs as part of their installation packages. Patricia has been vocal at HOA meetings about how solar companies are putting roofers out of business. When you installed your panels, she saw it as a personal affront. I was stunned. "You are telling me this whole thing was because of her husband's business interests?" "Absolutely. She has denied every single solar panel application that has come before the Architectural Review Committee in the past 3 years. Yours was just the first one that fought back. This information changed everything." If Patricia was using her position as HOA president to advance her husband's business interests and harm his competitors, that was a serious conflict of interest and potentially a breach of her fiduciary duty to the HOA. I called Robert and told him what Deanna had said. He was immediately interested. "If we can prove she was acting out of personal financial interest rather than in the best interest of the HOA, you might have grounds for an additional claim," Robert said, "but we would need evidence." "Do you know anyone else who had their solar panel applications denied?" Deanna might know. She said Patricia has denied every application in the past 3 years. See if you can find other homeowners who were denied. If there is a pattern of denials based on her personal interests rather than legitimate architectural concerns, we might be able to pursue a claim for damages. Over the next 2 weeks, I quietly reached out to neighbors and asked if anyone had tried to install solar panels. I found 4 other homeowners who had submitted applications between 2022 and 2024, and all 4 had been denied for vague, aesthetic reasons. 2 of them had simply given up and dropped the idea. One had moved out of the neighborhood rather than continue fighting. One, a man named Christopher Hayes, was still interested in installing panels but had been too intimidated by Patricia's denial to pursue it further. I shared this information with Robert, and we decided to send a formal demand letter to the HOA board. The letter outlined the pattern of denials, Diana's information about Patricia's conflict of interest, and the judge's ruling in my case. We demanded that the HOA adopt a formal written policy consistent with Arizona law that would allow solar panel installations with only reasonable aesthetic restrictions, and that they send written notice to all homeowners whose applications had been previously denied, informing them of their right to reapply. We also sent a separate letter to Patricia personally, informing her that we were aware of her conflict of interest and advising her to recuse herself from any future decisions regarding solar panels. The response came not from Patricia, but from another board member named Thomas Fletcher. Thomas was a retired accountant in his 60s who had been on the board for 2 years, but had largely remained in Patricia's shadow. His letter was apologetic and professional. He stated that the board had reviewed my case and the court's ruling, and they agreed that a new solar panel policy was needed. He invited me to attend the next board meeting in January 2025 to discuss the proposed policy. I attended the meeting with Robert. It was held in the community center, a small building near the neighborhood entrance. About 20 residents attended, which was apparently a large turnout for an HOA meeting. Patricia was noticeably absent. Thomas Fletcher chaired the meeting. He began by acknowledging that the HOA had made mistakes in handling solar panel applications, and that they needed to comply with Arizona law. He presented a draft policy that would allow solar panels on any roof slope, with minimal aesthetic restrictions such as requiring panels to be flush-mounted and using black frames to minimize visual impact. The policy explicitly stated that applications could not be denied based solely on visibility from the street, and that any denial had to be based on specific, objective criteria. The policy was reasonable and clearly drafted with legal compliance in mind. The board voted unanimously to adopt it, with Patricia abstaining because she was not present. After the meeting, Thomas approached me privately. "Brandon, I owe you an apology. I should have pushed back against Patricia's decisions earlier, but I did not fully understand the legal issues. When you sued and the judge ruled against us, it was a wake-up call for the entire board. Patricia has resigned as president, effective immediately. She claims it is for personal reasons, but I think we all know it is because of the lawsuit and the legal fees. She resigned." I was surprised but also relieved. Yes, she is remaining on the board as a regular member, but she is no longer president. I have been elected as the new president, and one of my priorities is to repair the HOA's reputation and relationships with homeowners. We cannot afford more lawsuits, and we should not be fighting residents who are trying to make reasonable improvements to their homes. I shook his hand. "I appreciate that, Thomas. I never wanted to be at war with the HOA. I just wanted to keep my solar panels. You were right to fight. And honestly, your lawsuit probably saved the HOA from even more expensive litigation down the road. If we had continued denying solar panel applications, we would have been sued over and over again." In February 2025, the HOA sent letters to all homeowners who had previously been denied solar panel applications, informing them of the new policy and inviting them to reapply. Christopher Hayes was the first to reapply, and his application was approved within a week. 2 other former applicants also reapplied and were approved, but the story still was not over. In March 2025, I came home from work to find my solar panels damaged. Several of the panels had been cracked, and the wiring conduit had been torn loose from the side of my house. My first thought was that it was storm damage, but there had been no storms that day. As I inspected more closely, I saw what looked like hammer marks on the panels and cut marks on the wiring. Someone had vandalized my solar panels. I immediately called the police. 2 officers arrived within 30 minutes and took a report. They photographed the damage and asked if I had any idea who might have done it. I hesitated, not wanting to accuse anyone without evidence, but I mentioned the ongoing conflict with Patricia Donnelly and the HOA. The officers noted this in their report and said they would investigate. I also called Desert Solar Solutions to get a damage assessment. A technician came out the next day and evaluated the system. 5 panels were completely destroyed and would need to be replaced. The wiring damage was extensive and would require several hours of labor to repair. The total cost of repairs would be around $4,000. I was furious. My insurance deductible was $1,000, which meant I would be out of pocket for that amount even after the insurance claim. And beyond the financial cost, there was the violation of having someone come onto my property and deliberately destroy my belongings. 3 days after I filed the police report, the investigating officer called me. "Mr. Nelson, we reviewed security camera footage from several of your neighbors. We have identified a suspect in the vandalism case." "Who is it?" "A man named Dennis Donnelly. According to our records, he is married to Patricia Donnelly, the former HOA president you mentioned." My blood ran cold. Patricia's husband had vandalized my solar panels. The conflict of interest Deanna had told me about had escalated into an actual crime. "What happens now?" I asked. "We are going to arrest Mr. Donnelly on charges of criminal damage. The damage exceeds $1,000, which makes it a Class 5 felony in Arizona. We will also be investigating whether Mrs. Donnelly had any knowledge or involvement in the vandalism." Dennis Donnelly was arrested on March 18, 2025. The police executed a search warrant on the Donnelly home and found a hammer and wire cutters in Dennis's garage that matched the damage to my panels. They also found text messages between Dennis and Patricia, in which Patricia complained about my solar panels and expressed anger about the HOA having to pay my attorney fees. While the texts did not explicitly instruct Dennis to vandalize my property, they established that Patricia was aware of his animosity toward me and my solar installation. Dennis was charged with 1 count of felony criminal damage. Patricia was not charged, but the investigation revealed that she had failed to recuse herself from HOA decisions involving solar panels, despite the clear conflict of interest with her husband's roofing business. The criminal case moved faster than the civil case had. Dennis's attorney tried to negotiate a plea deal, but the prosecutor was not willing to reduce the felony charge given the deliberate and malicious nature of the vandalism. In May 2025, Dennis pleaded guilty to felony criminal damage and was sentenced to 2 years of supervised probation, 100 hours of community service, and restitution of $4,000 to cover the cost of repairing my solar panels. Patricia Donnelly resigned from the HOA board entirely after Dennis's arrest. She and Dennis sold their house in June 2025 and moved out of Sunridge Meadows. I heard through neighborhood gossip that they relocated to Scottsdale, presumably to escape the shame and judgment of our community. Meanwhile, the HOA's new solar panel policy proved to be a success. By the summer of 2025, 12 homes in the neighborhood had solar panels installed or pending installation. The Architectural Review Committee approved every application that met the basic criteria of flush mounting and black frames. The neighborhood did not look industrial or cheap, as Patricia had predicted. Instead, it looked modern and environmentally conscious. In August 2025, I received my restitution payment from Dennis Donnelly. The $4,000 covered the full cost of repairs, and my solar system was restored to perfect working order. Desert Solar Solutions even upgraded some of the wiring as part of the repair, improving the system's efficiency slightly. I also received an unexpected letter from Thomas Fletcher, the new HOA president. The letter informed me that the HOA board had voted to refund all the fines that had been assessed against me during the dispute, even though the court had already invalidated them. The refund totaled $7,000, representing 7 months of fines at $100 per day for various periods between June and November 2024. Thomas wrote that the board wanted to acknowledge the HOA's mistakes and make amends for the stress and hardship I had endured. I was surprised by the refund, but appreciated the gesture. It felt like the HOA was finally taking responsibility for what had happened and trying to move forward in a positive direction. The full resolution of my case had taken over a year, from the initial installation of my solar panels in March 2024 to the final restitution payment in August 2025. It had involved a lawsuit, a criminal investigation, thousands of dollars in legal fees, and countless hours of stress and frustration. But in the end, justice had prevailed. State law had protected my right to solar panels, the HOA had been forced to change its policies, and the person who vandalized my property had been held accountable. Looking back on the entire ordeal, several lessons stood out. First, it is crucial to know your rights as a homeowner. If I had not researched Arizona's solar access laws and consulted with an attorney, I might have given in to Patricia's demands and removed my panels. Second, documentation is everything in an HOA dispute. Every letter, email, and conversation I documented proved invaluable in court. Third, sometimes standing up for what is right requires fighting battles you never wanted to fight. I did not want to sue my HOA or deal with criminal charges and vandalism, but I refused to be bullied into giving up something that was both legal and beneficial. The experience also opened my eyes to the broader problem of HOA overreach in America. There are millions of homes in planned communities governed by homeowners associations, and while many HOAs operate reasonably and fairly, others abuse their power and make life miserable for residents. The legal protections exist, but many homeowners do not know about them or cannot afford to enforce them. I was fortunate to have the resources to hire an attorney and fight back, but not everyone is in that position. In September 2025, I was contacted by a reporter from the Arizona Republic who was writing an article about HOA disputes over solar panels. She had heard about my case through court records and wanted to interview me. I agreed, figuring that publicizing what had happened might help other homeowners facing similar situations. The article was published in October 2025 and included interviews with me, Robert Mendez, and several solar industry representatives. It detailed my dispute with the Sunridge Meadows HOA, the court ruling in my favor, and the vandalism by Dennis Donnelly. The article also provided information about Arizona's solar access laws and resources for homeowners dealing with HOA opposition to solar installations. The response to the article was overwhelming. I received dozens of emails and phone calls from homeowners across Arizona who were dealing with similar HOA disputes. Some had been denied architectural approval for solar panels. Others had been threatened with fines or liens. Several had removed their panels rather than fight, and they wanted to know if they could get them reinstalled now that they knew about the state law protections. I shared Robert Mendez's contact information with everyone who reached out, and he ended up representing several new clients in solar access disputes. In every case, the HOA backed down once they received a demand letter citing my case and the relevant statute. Not a single one went to court, because the HOAs realized they could not win and did not want to pay attorney fees. The publicity from the article also caught the attention of Arizona state legislators. In January 2026, a state representative named Maria Santos introduced a bill to strengthen Arizona's solar access laws even further. The proposed legislation would impose penalties on HOAs that violate homeowners' solar rights, including mandatory attorney fee awards and potential fines payable to the state. The bill would also require all HOAs to adopt written solar policies consistent with state law and to provide notice to homeowners of their solar access rights. Representative Santos invited me to testify at a committee hearing on the bill in February 2026. I took a day off work and drove to the state capitol in Phoenix. The hearing room was packed with solar industry representatives, HOA attorneys, and homeowners who had dealt with solar disputes. I testified about my experience, describing the entire timeline from installation to vandalism to final resolution. I explained how Patricia Donnelly had abused her authority as HOA president to pursue a personal agenda, how the HOA had ignored clear state law, and how I had been forced to spend thousands of dollars and over a year of my life fighting for something I was legally entitled to have. Solar energy is good for Arizona, good for the environment, and good for homeowners' finances, I said. HOAs should be encouraging solar installations, not obstructing them. This bill would ensure that what happened to me does not happen to other Arizona homeowners. The committee voted unanimously to advance the bill. It passed the full House in March 2026 and the Senate in April. Governor Katie Hobbs signed it into law in May 2026, and it took effect on July 1, 2026. The new law required every HOA in Arizona to review and update its policies regarding solar panels by January 1, 2027. It also established a complaint process through the Arizona Department of Real Estate for homeowners who believe their solar rights have been violated. HOAs found to be in violation would face fines of up to $10,000 per incident, and homeowners would be entitled to attorney fees and damages. I was proud to have played a role in getting the law passed. What had started as a personal dispute with my HOA had turned into a statewide policy change that would benefit thousands of homeowners. As of today, July 3, 2026, my solar panels are still generating electricity and saving me hundreds of dollars every month. The system has performed flawlessly since the repairs were completed, and I am on track to break even on my investment by early 2027, even accounting for the legal fees and repair costs. Over the 25-year lifespan of the panels, I will save an estimated $75,000 in electricity costs. The Sunridge Meadows HOA is now under entirely new leadership. Thomas Fletcher stepped down as president in early 2026 after his wife's health issues required him to devote more time to family matters. The current president is a woman named Linda Morrison who works in renewable energy and is a strong advocate for solar power. Under her leadership, the HOA has actively encouraged residents to consider solar installations and has even organized group purchasing programs to get better rates from installers. 15 homes in Sunridge Meadows now have solar panels, and several more have installations scheduled for later this year. The neighborhood has become known in the area as a solar-friendly community, and some real estate agents even mention it as a selling point when listing homes in the subdivision. As for Patricia and Dennis Donnelly, I have not heard anything about them since they moved to Scottsdale. Dennis completed his probation without incident, and as far as I know, the couple has stayed out of trouble. I do not wish them ill, but I do not forgive them for the damage they caused, both to my property and to the community. The entire experience taught me that homeowners associations can be powerful forces for good or ill, depending on the people in charge. A vindictive, power-hungry board member like Patricia can make life miserable for everyone, while a reasonable, thoughtful leader like Thomas or Linda can create a positive community environment. The key is for homeowners to stay informed, participate in HOA governance, and stand up for their rights when necessary. If I could go back to March 2024 and do things differently, I honestly do not know what I would change. I wish I had submitted an architectural approval application before installing the panels, But given Patricia's track record of denying every solar application, I doubt it would have made a difference. She was determined to prevent solar installations regardless of what the law said, and the only way to stop her was to fight back through the courts. The fight was worth it, not just for me, but for every other homeowner in Arizona who wants to install solar panels and reduce their carbon footprint. State law protects that right, and no HOA should be allowed to override it based on personal biases or business interests. My final piece of advice to anyone dealing with a similar situation is simple. Know your rights, document everything, and do not be afraid to fight back. HOAs count on homeowners being too intimidated or too exhausted to challenge their authority. But when you stand up for yourself and use the legal system properly, justice usually prevails. The solar panels on my roof are more than just an energy source now. They are a symbol of persistence, of refusing to back down when you are right, and of the importance of standing up to bullies with authority. Every time I look at them, I remember the fight it took to keep them, and I feel proud of what I accomplished. My electric bill last month was $37. The sun is still shining, my panels are still generating clean energy, and Patricia Donnelly is no longer in a position to tell anyone what they can or cannot do with their own home. That feels like victory.